During a pretrial deposition, if I yell out, "Objection!" why is it that in most instances I'm going to tell you to go ahead and answer the question anyway? You want to know the answer? Come join me for a walk through the neighborhood as I tell you exactly why I will tell you to likely go ahead and answer the question anyway. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. You brought a lawsuit against a careless doctor and hospital staff claiming that they caused you significant harm and injury. The doctor and the hospital claim that they did nothing wrong. Now, during the course of your lawsuit, you are going to give testimony. You're going to answer questions put forward by the defense attorneys, and they are going to do that in a deposition. A deposition is really a question and answer session that's given under oath. You swear to tell the truth. And in response to the questions you are asked, all of your answers represent your sworn testimony. And even though this is likely happening on a Zoom video call or in your attorney's office, there's no judge present, there's no jury present, but the answers that you give during this question and answer session not only represents your sworn testimony, but carries the same exact weight as if you are testifying at the time of trial. Many people don't understand that. It is so significant, and it gives the defense an opportunity to learn for the first time exactly what happened to you, and in your own words, what injuries you suffered and what problems you have now because of those injuries. So it is a very important component of any medical malpractice lawsuit, an accident lawsuit, or even a wrongful death lawsuit. So now let's get back to the topic I raised in the title of this video. If during the course of you being questioned, I yell out, "Objection!" you know to hold on a minute. You know to wait until I tell you whether or not to answer that question. Now, why would I yell out the word objection? I'll tell you why. The question may be improper. The topic that you are being asked in that question may be improper. Something about that question, I think, is improper. And now, what do I do to alert the other side to the fact that I think it's an improper question and you should not be asked that question? Simple. I yell out, "Objection!" Hey, I object to that question. Okay. Once I do that, what happens then? Now, typically, I will give the reason why I think the question is improper. Sometimes, the defense and I will get into a legal discussion about why I believe the question is improper. And now there's going to be some legal bickering back and forth between the attorneys about whether the question is or is not improper, and whether you have to or do not have to answer the question. You should know that in almost every instance in these civil lawsuits in New York, in almost every instance, you will be required to answer the question even though I don't think it's an appropriate question. Did you know that? Not many people understand that. They don't talk about that. Many of the questions you will be asked, you will think have absolutely nothing whatsoever to do with the claims that you are bringing or with the defenses that the doctor and the hospital are raising. And you might be thinking, why do I have to answer that question? It's got nothing to do with the issues in this case. And you may be 100% correct. Since this is the discovery part of your case, the defense is actually entitled to probe, to learn about you and your background and your history, to learn about things that went on with you in the past, to learn about things that are related or tangential to the issues in this case. You may think it's got nothing to do with it. I may think the same thing. But I can place an objection on the record by yelling out, "Objection!" Tell the attorney why I think it's inappropriate. But then I still have to turn to you and say, "Okay, Mrs. Jones, go ahead and answer the question anyway." And you might be confused and say, "Wait a second. You don't like the question. You don't think it's appropriate. I don't think it's appropriate. Why do I have to answer the question?" Because this is discovery. And because of that, the courts tend to favor giving more information rather than less information. And that means that even though you are answering a question that we believe to be inappropriate, it does not mean necessarily that if your case goes to trial, the defense will be able to use that same question or use that answer when questioning you later on. Just because you give an answer at your deposition doesn't mean your answer will be admissible at the time of trial. So, the defense does have some latitude in asking you questions that we think are not appropriate. There are very few instances where I can actually appropriately tell you not to answer a question, and I'll save that for a different day. But for the most part, when you are asked questions during your deposition, even though I may not like the question, even though I think it's inappropriate, even though I think the topic is clearly unrelated to the issues, now I can raise the objection, I can have an argument, a legal argument with the defense attorney about the question and about the topic, but in all likelihood, I'm going to have to tell you to answer that question anyway. So why do I share this with you? I share it with you just to open your eyes and help you understand exactly what happens in these types of pretrial question and answer sessions known as a deposition. By the way, lawyers also call it an examination before trial. I realize you're likely watching this video because you want to see the great scenery. No, I realize you're watching this because you likely have questions of your own about your own matter. Well, if your matter did happen in New York, and you have not yet started a lawsuit and are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.